Brian from the Disability Digest here. If you get denied by a judge at a Social Security disability hearing, is it the end of the road for you in your quest for benefits? Maybe, maybe not. So that's what I'm going to go through in this video. Hopefully you are following our information here at the Disability Digest and you're at the initial application phase and you do what's right and you get your benefits approved and you don't end up in court, because that's really the last place that you want to be, because your case is at the mercy of a judge to determine if you are qualified to receive your benefits. So what I want to help you understand, first of all, is the process of going through disability benefits. Briefly, you have an initial application. If you've applied and been denied that, in some states you file a reconsideration. There's 10 states that don't have this appeal, and then you would go on to a hearing. So if you go to a hearing in front of a Social Security disability judge and it is denied, you'll see on the screen there's steps 4, which is the appeals counsel stage of the approval process, which you can file an appeal, which is telling the Social Security Administration that you'd like to have your hearing reviewed. And the approval rates for that are low. I showed them on this screen back here. These maybe 1% of them are overturned. It fluctuates every year, but it doesn't go to 10. So then after the appeals council, if you get denied at the appeals council, which most do because it's only 1% approval, then you would go on to if you chose to, you would go on to a federal appeal, which means that you are appealing to the federal court that your Social Security disability case was not handled properly. These are very general framework for the appeal level. I'm not going to get into the weeds on it here, but I just want to help you understand that you do have options. So one of the best strategies that I've found in my 18 years of helping people go through this process is, if you get denied at a hearing, is to have your case reviewed by a legal team that does this specific work from the appeals council, federal appeal case, and higher. There's like maybe 2 people that I could really rely on that do this work good. So the point of doing this is, if they review your case and say, yeah, you know what, you got a shot at it, at least you can make that decision based on their findings to go forward or not, right? Now, if they say no, you don't, well, it probably is not a good idea to go forward, because if they can't win it, it's going to be difficult for anybody else to. This is just my opinion. You find somebody that's really good at it. And maybe your current legal team, if you have one, has experience in doing this, and they can give you that guidance as well. But let's say, I'm going to give you a couple of scenarios here. Let's say that you do go on to the federal appeal level. So you've gone through the appeals council, it gets denied. Then you go on to the federal appeal. When your case goes into the federal appeal level, you can start a new application, because technically your disability case is now being handled at the federal level. It's not a Social Security case anymore. So this is a little known strategy, so you can have kind of 2 cases going. Speak with your legal team about how to manage the nuances if one gets approved before the other. But this is definitely a sound strategy that you can do. The other thing is, if there's a flat-out no that your case is not going to be winnable at the Appeals Council Federal, then you can apply again. But keep in mind that you already had a case that went to court, and that case has been heard, and the information and the evidence that's in there is not going to be opened again with a new application. They will evaluate anything from the day after your hearing that you had forward. So if you have a new diagnosis, or if you have a diagnosis that has increased in severity, maybe you have a condition with a pain level that was moderate and it went to severe, or mental health condition that had the same same change, then that's new evidence or a new condition. Or perhaps you changed an age bracket. You went from 49 into the 50s, or you went from 54 to 55. So a legal team can help you understand like how to play this game at that level. But if you just got denied and you went right back out and opened a new case, your chances of getting approved on that case are going to be slim. It's going to be difficult because you don't have any new evidence. And so that's the point on that. One last very important thing that I want to make sure that you understand on this is your Social Security disability benefits expire. Your date last insured expires. It's about 5 years after the time that you stopped working. So if you've gone through the cycle and went to a hearing and you're still within that 5 years where your date last insured is alive, then you can file again. So that's one other major issue that you need to take into consideration on this. So let's recap what your options are. If you go to a hearing, then you can go, after it's denied, you can go to the appeals council. And then on to federal appeal. When you're at the federal appeal level, you could start a new case, speak to your legal team about the nuances of that. And then, of course, you want to make sure that you are aware that if you're still insured and what your date last insured is. So these are the key things about helping you understand the end of the road and where it is and where it isn't. I hope you find this helpful. For more information to help you get your disability benefits approved, help you understand how to keep them and maximize them, look for a link around the video to join us as a member or update us as a member, and of course stay tuned for more videos here from the Disability Digest. Make it a great day.